All right, guys, welcome to week 4. We're getting ready to start the halfway point. It's 4th of July week. I'm going to try to be good to you this week and let you enjoy it with your family and friends. We're going to talk about employment law. This is something kind of like contract law where you all are going to be involved in this, whether you want to be or not. Whether you're on the end of it, if it's unfortunate, or you're the one that's having to deal with it from an employer standpoint. Before we get started, just to let you kind of know what the plan is for the week. You'll still have an article post that's due by Thursday. However, you're not going to have to respond to anybody. Just have to post the article for everybody to be able to see. You'll still have a case study due on Sunday. Keep in mind, guys, that make sure on this stuff that you're taking your time and doing good work. When you turn in those case studies, make sure that you spend time on your PowerPoint. Make the font look good. Add some pictures. Make it look like you've put work. Make sure your grammar's right. Okay. And then for the article, it may be kind of difficult to find an article on sport, but you're looking for things maybe that have to do with discrimination possibly as you go through. If you can't find one dealing with sport, post one that doesn't deal with sport, but then relate it back to how it could apply to sport. So here we go. These are just kind of common employment issues. An employee is fired, a qualified employee is not hired, qualified employee is not promoted. An employee's work situation is made so bad that they quit. An employee could be injured, could be injured because of what they're doing, could be injured because of the conditions that they're working in. And so some topics that we're going to kind of look at for employment law is this concept of employment at will, which basically means that you can fire anybody or you can terminate a contract. Either party can terminate a contract at any time for any reason. We're going to look at hiring, promotion, retention, sexual harassment, and we're going to look at some of the employment laws that will apply to you guys. So understand that employment is just a contract. Okay, so it's an agreement to perform some kind of service in return for salary benefits. And it begs to ask this question of who is an employee. I think Trevor might have asked this about why are college athletes not paid, and this kind of has come up before. I know it's a hot button issue now, but this is not the first time, and we'll talk about that in a second. Is a university scholarship athlete an employee? And so what I said before is this employment at will is any of us can terminate it at any time. Okay, the exceptions of why it can't be terminated would be if it is impacted by federal legislation, if there's an implied contract, meaning that you don't have anything on paper, or if it's public policy that you can't terminate it. Some things that you see that will go into this talking about employment: the Civil Rights Act, the ADA or the Americans with Disabilities Act, OSHA. When you start talking about injury on the job, you're looking at workers' compensation, so you're looking at tort liability, which we just talked about. Whether the act was somewhat within the scope of employment. You're also starting to look at contract liability. What's the liability in the job we're doing? So going back to is the athlete is a scholarship athlete an employee? So Coleman versus Western Michigan, and I think this is around 1983, if I'm not mistaken. This kid, it was 1983. Kid gets hurt. They keep him on scholarship for the remainder of the season, remainder of the year, and then they yank his scholarship after that year. And he takes him to court, basically saying that they didn't have a right to terminate him because he was an employee. And so it works its way up several courts. And so it came basically to these 4 principles, or this applied test that they came to make this judgment was, did the employer's right to control or dictate the activities of the proposed employee? Well, yes, they did. He's a scholarship athlete. They told him when to practice, when to lift, all that. Did the proposed employer's right to discipline or fire him? Yes, they did, because they did. Did the payment of wages, and particularly the extent to which the proposed employee is dependent on the payment wages or other benefits for his daily living expenses. That was a little bit of a gray area, but I think the court did say that he was that they did. The catch was this number 4, and this is why they ruled in favor of the university. Whether the task performed by the proposed employee was an integral part of the proposed employer's business. Well, he was one scholarship athlete, and athletics isn't the business of a university. Education is, and so that's why they found for the university. So let's look at kind of some Occupational Safety Health Act, some OSHA. It's a typical health and safety concerns at a university or at a job. You just have to kind of ask yourself this. And so basically what this does is it mandates employers to meet safety standards. And basically it says that they have a duty to keep their employees safe. It also protects employees who file complaints, okay? And it requires record keeping when you have 11 or more employees. So moving to a different deal, looking at hiring and promotion retention. So discrimination is this is a huge issue when it comes to hiring, guys, and firing and promoting. And the Civil Rights Act of 1964 basically said that dealt with hiring on the basis of race, color, national origin, gender, and religion. Okay. Age Discrimination for Employment Act, ADEA, and Americans with Disabilities Act. All of these have to pertain to how we decide who we want to hire. And then a more recent, but a policy which I'm not sure how I feel about exactly within the education standpoint is affirmative action, which is basically saying that you basically have slots available, or you protect a process where employees actively seek to hire out people from protected groups, meaning the race, color, national origin, gender. And so probably we see this most prominent now is in big universities where they're saying, hey, we're going to basically hold so many spots in our the number of students we let in each year for students that are minority students. That's a process that's been kind of a hot button issue, not recently, but probably in the last 10 years. So the Civil Rights Act says the protected classes are basically minorities, gender, mainly female, and people with certain religious values or just religion in general. State laws could expand on this to protect people with different sexual orientations. Hasn't yet, but is in the process of it probably. And so discrimination comes in when you're treating either an employee working for you or somebody that's applied unequally based on some characteristic or trait. And so we have to ask, well, how do we find out if discrimination occurs? And, it can be direct. You were not hired because you're whatever, a woman. You're black, you're whatever, you're old. Obviously that would be completely ignorant on the part of the employer, but it happens. Indirectly is probably the most common thing you see, and you have to come back to trying to prove this, which is a little bit harder to do. And so it starts with disparate treatment. And so what disparate treatment basically means is the burden is on the business to, if they're sued for discrimination, they have to prove why they didn't hire this person, okay, or why they were not qualified. Disparate impact is basically the claim. It's a discrimination claim that can be brought on the basis of either intentional or unintentional discrimination on the part of an employer. So essentially, to kind of make that into common sense, if somebody sues you for discrimination, you have to be able to prove as a business owner why you didn't do that. So here's just kind of some case examples. So a member of a protected class, you make it up, whatever you want, applied and was qualified, was rejected by the employer, position remained open or was filled by a person not in a protected class. Victim files a claim or a lawsuit. The defense is basically used to justify discriminatory practice, so they have to prove it. And so one thing you'll see is occupational classification. So basically what they can say is that they need a certain type of person to carry out their business. So maybe maybe it's a female-only fitness gym, and a male applies who has all the certification, and they don't hire him. He tries to sue them. They can basically say, hey, you're only dealing with females. We need a female to work here. So another issue that comes into this is that your workforce should reflect the same percentage of members of the protected class as the local labor market. So wherever your business is, it should kind of have the same makeup of people as the area it's located in. And so that's pretty challenging. Means you got to do statistical analysis, you've got to get data, and you've got to be able to define, well, what's the local market? And so another example of a case is employment practice has a discriminatory effect, connection between employment practice and disparity. So they use to justify the discriminatory fact as business necessity. So a valid business reason for choosing someone outside of a protected class could be potentially gender. They need somebody who's a certain height or weight, strength, religion. They could maybe try to say that, hey, you need so many days off because of when you worship, and we need somebody who can work these particular days. That's the reason you were not hired. Something you might see from a race standpoint is a business had a valid reason to hire only workers with high school diplomas, and it just happened to be that the most people who applied were non-minority. Sometimes you can't necessarily help who applies. Sometimes you can. Age, possibly that, you need somebody who has strength and endurance, and that most of the workers that applied were under 60. Again, so it's not always discrimination when somebody doesn't get hired. Age discrimination only applies on the basis of people 40 or over into businesses with 20 or more employees. So another example of a case, you're 40 years old or older, you applied or qualified, you were rejected in circumstances that implied discrimination. And so if that happens, you got to prove, or the process goes on. I mean, it goes on to the same deal we were just talking about, where they've got to prove why they hired somebody who was younger. All right, moving on to discrimination against disabilities. The ADA, okay, it's an older act, but it was really put into focus in 1990. And basically the process is you have to prove a disability substantially limits one or more major life activities. You have to prove you're qualified for the job, and you have to prove you're denied the job because of a disability. Employers have to provide a reasonable accommodation. Meaning if somebody applies as a disability, they have to try to put them in a work environment that they're able to do. And it can't produce undue burden, meaning it can't put so much burden on the employer that they're not able to do this. And so you see this a lot. Some high profile cases. There was a case involving Little League Baseball and a coach who was in a wheelchair who wanted to coach first base. They wouldn't let him. He sued them. It was Anderson versus Little League Baseball. He won. Another more recent example was a golfer who had a handicap named Casey Martin, qualified for the PGA Tour, but was unable to walk the course. He wanted to use a golf cart. The PGA said no, that was a violation of their rules. It gave him an advantage. He sued. It went all the way up the courts, and he ended up winning. Moving to sexual harassment. So here's kind of what goes on as far as elements of this. Any unwelcome sexual advance not desired by the employee, conduct that creates a hostile or abusive work environment, and this can be either verbal or physical. Two most common types you see in sexual harassment: quid pro quo, which basically means you perform some kind of sexual act in return for something else, or just creating a hostile work environment. Other employment laws, just for you to know: COBRA basically requires an employer to continue medical coverage as an option to terminate an employee for a certain amount of time. HIPAA prohibits on exclusion of medical coverage and medical record confidentiality. You have to sign those forms at Reinhardt. FMLA, unpaid leave of 12 weeks for family or medical reasons is required. Fair labor standards, which covers child labor, overtime, minimum wage. We've already talked about civil rights. We've already talked about ADEA and ADA. So, guys, to kind of reiterate for this week, and I'll put it in an email, make sure that you're on top of what you're doing, that you do good work, that you put your time in. You have a case due or an article due on Thursday, case due on Sunday. Have a great, happy 4th of July week. Enjoy it. Enjoy the many blessings that you have with your family and friends. Take it easy.